Yeah. Is it live? Hello, everybody. Please grab your lunch and come on in. My name is Elliot Botvinnik. I'm on the faculty here in bioengineering and medicine. And I want to welcome you to our second annual Medical Device Day. For those of you who are not aware of this, I'm the site leader for what's known as the UC Center for Accelerated Innovations. And today's event was centered around helping potential applicants strengthen their proposals. The proposal was to a grant program aimed at accelerating the project towards commercialization. And we have 3 talks this morning, or this afternoon, that I had organized in an attempt to both educate UCI people on the 101s of starting a business, building up an IP, and we have a keynote speaker that is educational and inspirational. So on that note, Mark Boyron is our first speaker. He's in corporate law at Rattan & Tucker. And Mark, please take it away.
All right. Thanks. Good morning. As Elliot said, I'm Mark Boyron. I'm an attorney at Rattan & Tucker. Joined Rattan & Tucker about 1.5 years ago. Before that, I was an attorney in Delaware at a law firm that kind of operates differently from most law firms. The way Delaware corporate law firms work is you have firms like Rattan and other kind of national law firms that call you for advice on specific Delaware issues. And it turns out that a lot of startup issues are issues that are specific to Delaware law. And so a lot of these things are things that I was talking to other law firms about. One of the big things I see with startups is just running into legal risks that are completely avoidable. And so the reason it matters so much as a startup, even more than if you look at a middle market company or a large company, is that startups are all dealing with capital structure issues, which means whether you actually own shares of the company and as many shares as you own and whether you're going to retain that same percentage ownership. And then the second one has to do with voting and whether you control the voting of the company or not. And all of those are issues that too many startups run into. And a lot of that has to do with understanding the legal aspects of startups. So I want to cover 3 topics here. One is understanding your choice of entity. The second one is understanding kind of your corporate documents. And then the third one is understanding your capital raising options. So turning first to your choice of entity. One thing that everyone's run into, and you've probably seen charts like this, is what kind of entity should I use when I'm starting my company? The C corporation turns out to be the entity of choice, even though there are many downsides. So what you'll see is there's actually a lot of similarities between them. The first one has to do with liability of owners. You've got a C corporation, stockholders are not going to be liable. Same thing with an S corporation, same thing with the members of an LLC. Also, stockholders can be involved in the management of the company, both in a C corp and an S corp and the members of an LLC. Where you start seeing some differences has to do with the flexibilities in the entities. So a C corp is actually not all that flexible. C corporation can have multiple classes of shares and can have multiple series within those classes, but ultimately there's a very rigid corporate code that must be abided to. S corporations are this is kind of a deal breaker for S corporations when you're looking to raise capital. The biggest reason being, especially once you get kind of to a Series A round or later, is that you can't have more than one class of shares. And so, right away you couldn't have common stock as well as preferred stock, and so that option kind of runs away. An LLC is perfect. You've got all the flexibility that you want, but that's not the only thing that matters. You then turn to pass-through treatment. And you also see that a C corp's actually not the best. You've got 2 layers of taxation. You've got taxation at the corporate level, and then you've got taxation at the shareholder level. Whereas an S corp and LLC, you've only got taxation at the shareholder level. There's no ownership restrictions for a C corp or for an LLC, but as you'll see for an S corp, there are several restrictions that make it almost impossible to raise capital and deal with those. So really it comes down to a C corporation or an LLC, and the situation that you run into there is, well, why aren't we using an LLC when there's all these benefits? And a lot of it comes down kind of historically. LLCs probably 20 to 30 years old. Historically, sophisticated investors are used to dealing with C corps. There is a very large body of law in the C corp context, and so it ends up what ultimately ends up happening is that when you're looking to raise capital, investors, especially sophisticated investors, want to see C Corps. If you have an LLC, they may very well ask you to convert from an LLC to a C Corp. And that's something that can be done actually quite easily, other than it's going to require a stockholder vote, which could be a problem. But the documentation's easy, but then there's also a cost associated with it that's better to avoid. But now that we've determined a C Corp's the preferred entity of choice, the question is, where do you incorporate it? And as many of you heard, Delaware is the preferred state of incorporation. A lot of you may think that that's tax-related, and it's not tax-related in any way. There are many other reasons, though. First of all, you've got a very experienced court there. The court in Delaware deals with probably hearing 20 business-related cases every week. And they're only hearing business-related cases, essentially. Whereas you go to a California court, they're going to hear a criminal case, a business case, and then some divorce disputes. So they just don't have any expertise there in deciding issues that are related to really businesses and startups. The next one, and it's a related point, is that the corporate case law is very built up in Delaware. You've probably got about 5 to 10 kind of official cases that come out every week by the Court of Chancery. That helps define the body of law. So when you're dealing with any kind of dispute, you know what to expect in terms of the outcome. And even where there isn't a defined outcome, based on the case law that exists, you're able to get a pretty good idea of where a court would come out. You've also got judges that are appointed rather than elected, which ends up meaning that you have very high-quality judges. The judges in the Court of Chancery are actually very well respected, and it's a very desirable position. And so, the governor of Delaware ends up electing judges that come out from top law firms and that are very good. The corporate statute is amended annually. A lot of other statutes in other states don't get amended very often at all, but basically what you have there is you've got the top Delaware law firms that listen to other law firms that are dealing with these transactions all the time, as well as the business community, to hear what kind of issues that they're facing and dealing with as a result of the statute, or that could be made easier in the statute. And so that's quite a big benefit there. The Secretary of State is efficient. The Secretary of State's the one that's going to accept all the filings. If you deal with California, you've got a 24-hour turnaround that's probably going to take a few days. Whereas if you're dealing with the Secretary of State in Delaware, a 24-hour turnaround is typical. You can even get a 30-minute turnaround if you're willing to pay. It's a pretty big box, but it can be done, and it does get done commonly. Lastly, and probably most importantly, is, again, investors may require you to be incorporated in Delaware. Again, I ran into this just last year. A company I was representing was raising a Series A round, and the VC firm that was open to investing in them just simply said, you're a California corporation, we want you to be a Delaware corporation, you need to convert before we're going to put any money in. And that comes up all the time, and so you end up converting. Again, you need a stockholder vote, which can be problematic in certain instances, not generally, but it can be, and then there's expenses associated with it. So you've got a C Corp that's going to be incorporated in Delaware, and then the question is, okay, well, what's your role in that corporation? And one of the things I commonly find with startups is not really understanding the hierarchy in a corporation that ends up, or potentially is important. So you've got the stockholders that you could view as kind of the supreme beings. They're ultimately going to decide essentially everything. And the reason is they elect the board of directors. They also remove directors from the board. So if they're not happy with the direction of the company, they just end up removing the directors, replacing them with whoever they please. The board of directors could potentially have a board of advisors or board observers. As a board advisor kind of implies, they're advisors to the board. They don't actually vote. They're not going to have fiduciary duties, but they are going to provide advice that may be valuable to the board. Board observers usually come into play when you have a minority stockholder. That stockholder doesn't have enough shares to really, for it to make sense for them to have a position on the board. But they want to know what's going on at the board level because they might own a significant minority or enough for it to make sense. And so in that situation, you're going to have that minority stockholder. Generally, that person is going to go on the board to listen to what's happening at the board level, as well as receive materials from the board. The board of directors then is the one who elects as well as remove officers, and the officers are going to hire and fire employees. The reason all this matters is when you're a stockholder, it's common to see a stockholder that ends up signing a document in the capacity of an officer or something of that nature, or you see stockholders that take very lightly when they see kind of written consent of the stockholders on the document. Well, the second you see a written consent of stockholders or you have a stockholders meeting of any sort, you should be paying specific attention because something major is happening. So now that we've talked about your choice of entity, I want to go over kind of the corporate documents. The most important corporate document is going to be your certificate of incorporation. It's really going to govern the most crucial aspects of the corporation. One of those is going to be the authorized number of shares. So you're always going to have a provision. It's usually going to be, Article 4 in the certificate of incorporation that's going to say this is the authorized number of shares. If there's common stock as well as preferred stock, then it's going to have a kind of a subgroup of how much common stock is authorized and how much preferred stock is authorized. And when it comes to certificate of incorporation, it's, I guess, important to remember that it's a document that morphs over the lifetime of the entity. In that, when you first start a company, the certificate of incorporation is usually a few pages. It's not very complicated. But once you go on and you raise capital, that document becomes a lot more lengthy and a lot more complicated. But if you've got the authorized number of shares set in your certificate of incorporation, that number cannot be changed without both the board approving it and the stockholders approving it. So an example will tell you kind of why this is important. So if you have 3 stockholders, each of them own 33% of the company, or they each own, let's go 33.3%, or 33.3 shares out of 100 that have been issued. You have 200 shares authorized. Now you have 2 of those 3 shareholders who on their own could go ahead and issue additional shares given that they're most likely to be the members of the board and the board would be able to issue those shares. And there's another 100 shares and that's 100 shares worth of dilution to the minority shareholder that can do nothing about it. However, if that certificate of incorporation, instead of having 200 shares authorized, had only 100 shares authorized, you would then need to get stockholder approval as well as board approval to be able to actually increase the authorized number of shares. And it's very common in a certificate of incorporation for the shareholder to actually have some kind of veto right when they hold something like 33% of their shares. And so that shareholder would be able to prevent that dilution. Next is voting rights are going to kind of determine control over your corporation. And when you have your kind of startup company with its first certificate of incorporation, you're generally not going to have any voting right provisions in your certificate of incorporation. But as you kind of move along and you raise around a capital, suddenly you're going to have plenty of voting provisions that go in there. And the biggest one, most important ones being preferred stockholders are generally going to have some kind of veto rights to be able to make or control major decisions. But even in your startup certificate of incorporation, if you have one shareholder who owns 55% of the company, another shareholder owns 45% of the company, technically that 55% can do whatever they want. The default under Delaware law is that a majority of the shareholders can approve any transaction. And so even in that initial certificate of incorporation, you might want to have veto rights for that minority shareholder under certain circumstances like amending the certificate of incorporation or entering into any kind of merger or other major transaction. Next one is dividends. Those, again, in your startup certificate of incorporation, you're not really going to see them in there. However, when you go and raise any Series A rounds, you have preferred shares, there's going to be a specific provision dealing with dividends. These obviously matter because they're the easy way to take money out of the company or at least to accrue capital for those preferred stockholders. Dividends can only be issued by the board of directors, and so paying attention to what's in that certificate of incorporation with respect to dividends is important because it's going to add value to the preferred stockholders that they wouldn't have otherwise. Next, conversion rights. Again, this relates to your post-raise certificate of incorporation, but if you have a holder of common stock and a holder of preferred stock, the certificate of incorporation is going to provide specific rights for the preferred stockholders. One of it is going to be conversion rights. And that's going to say how many shares of common stock into which preferred stock may be converted upon conversion. And it's going to be crucial to see what that conversion ratio is. If you've got, for example, a 1-to-2 conversion ratio, then that means a holder of 100 shares of preferred stock could convert into 200 shares of common stock, which creates further dilution. So again, that's something that you're going to see in every single kind of post-raise certificate of incorporation, but it's also something that you're going to want to pay attention to and make sure that that ratio is what you're thinking it is. The next one is pro rata rights, which is kind of an anti-dilution mechanism. And again, your post-raise certificate of incorporation, the question is, if there's going to be additional shares of stock issued, does anyone have a right to participate in that? If they don't participate in it, then they're going to be further diluted. If they have pro rata rights, then they're going to have the opportunity to purchase shares so as to not be diluted any further as a result of that capital raise. In addition to the certificate of incorporation, the bylaws are another kind of corporate document that are important, and they play lesser importance. Part of the reason for that is that certificate of incorporation is kind of the holy document, and the bylaws are subject to the certificate of incorporation. So anything that is in the bylaws can also be in the certificate of incorporation. Anything that's in the certificate of incorporation and is contrary to something that is in the bylaws will trump the bylaws. And so that's something that's, we'll see is actually going to be relevant in certain situations. The bylaws end up being really a procedural mechanism that'll deal with mostly things like meetings of directors and then meeting of shareholders as well as voting rights. So the board of directors, the default under Delaware law and what you're going to see in most of your bylaws is that a majority of the shareholders is going to constitute a quorum. And then you've got a majority of those present at a meeting of shareholders where a quorum is present. It's going to be the one to approve any action taken. So what that ends up meaning is that you could technically have just over 25% of the shares approving a corporate action. It's just another reason why you want to make sure that the proper mechanisms are put into place to protect you if you're a minority shareholder in the company. The board of directors also has a similar structure where a quorum is a majority of the directors, and then approval is going to be done by a majority of those present at the meeting. One thing to remember, because a lot of actions are done by written consent, either at a board meeting or at a stockholder meeting, depending which one. At a board meeting, you're going to need unanimous approval. And so you can, as a director, block any action by written consent. Whereas as a stockholder, unless you have some kind of protective provisions in your certificate of incorporation, there's nothing you're going to be able to do about it if somebody owns 50.1% of the shares. They can act by written consent. In Delaware, they don't even need to give you notice. They give you notice 10 days after they've taken the action, so you can have kind of changes to your certificate of incorporation or any other action taken by the shareholders without you ever even knowing about it if you haven't paid attention to what's in your bylaws and certificate of incorporation. The number of directors is often set in the bylaws, or really the method should be set in the bylaws. What you end up seeing oftentimes is that the bylaws say, for example, the number of directors is fixed at 5. I personally, and I've seen too many issues where that is a big mistake and will lead to mistakes down the road. The better way is to basically say either the stockholders or the board fix the size of the board. The reason this matters is imagine you've got a bylaw that says that the board is fixed at 5 directors. You then have 5 directors that are elected, and at one point in time, the board or the shareholders decide, well, really the shareholders decide that they want to elect a 6th director. So they go ahead and they elect a 6th director, even though the bylaws only say 5. And this happens all the time, believe me. The problem with that is now, if you recall kind of what constitutes a quorum, let's say you've got the board that wants to act at a meeting. You've got 3 directors who show up, which should constitute quorum. However, one of those directors is that 6th director. You suddenly don't have a quorum. And let's imagine that that board just approved an amendment to its certificate of incorporation that the stockholders also approved to increase the authorized shares. They now issue those additional authorized shares to shareholders. Well, that issuance is not valid. And I could go on for 10-year periods of time where I've gone through the corporate documents and you trace it back and everything's messed up from that initial point in time. Thankfully, Delaware's put in a procedure 2 years ago where you can fix all of this. Probably costs close to $15,000 to $25,000 to fix it all, but it can be fixed, whereas before it literally couldn't be fixed. But bottom line is, having that flexibility is a very important thing. The method of electing officers is going to be set out in the bylaws. This is really just informational so that you understand that officers are elected to set forth to a specific procedure in the bylaws. Almost all the time that's going to be the board electing the officers, but it's something to pay attention to. Also, transfer restrictions are going to be can be in bylaws. I mention this only because they're rarely in there, and people don't focus on it because they're typically in your certificate of incorporation, or they can be in some other document that the board of directors approves. And so oftentimes they're not in the bylaws and people don't focus on this, except having some kind of restriction on whether you can sell your stock is very significant, and it's something that you should be paying attention to. The next corporate document I want to talk to is your organizational consent. Most people view this as a complete, administrative matter. It's the first action that the board of directors is going to take after forming the entity. But there's actually some important implications, important things that are done. First of all, typically they're going to approve bylaws. And so you're going to want to pay attention to what bylaws are attached to that consent, or you're going to want to see it because that's going to be really very relevant to your rights. In addition, they may set the size of the board. As we just talked about, it should be the board setting the size, or the stockholders. And so you want to pay attention to whether that size of the board is being fixed at the correct size. Same thing for officers. If you expect to be an officer, you want to pay attention to the fact that organizational consent actually elects you as an officer. It's also going to actually cause the issuance of stock. So as we're going to talk about, there's going to be you typically have a founder stock purchase agreement that's going to deal with the terms of your stock. But it doesn't change the fact that the board's the one who actually needs to issue them, and the number of shares that they set out in this resolution is going to be the number of shares that you receive regardless of what that stock purchase agreement says. Lastly, they're going to approve other corporate actions, and there's going to be a broad set of them. But the reason I mention this one is more about paying attention to who gets to do what. So assuming you're an officer in the corporation, you're going to care about what rights you have, for example, with respect to a bank account. Who's allowed to open bank accounts, who's allowed to deal in the bank account. The resolutions could be drafted so that any officer can deal in the bank account, and that's often the case, especially where everyone's trusted, and there's no reason for that to be any different. That being said, there's other situations where you just might want only the CFO to have the right to access the bank accounts and deal in that. So again, it's something you want to pay attention to in the organizational consent. Next thing is the founder stock purchase agreement. As I said, it's going to govern the terms of the stock that you've received. One of the biggest issues that you're going to run into when you're dealing with founder stock purchase agreements is the vesting of shares. So this is one of the almost difficult discussions to have with clients because clients typically think that it's something that can be ignored. So vesting really goes to, okay, you've now purchased your shares, you technically own those shares, but at certain times those shares can basically, for simplicity, be taken back by the company. And so the question is, should that be something that you have in your stock purchase agreement? If you think about it from a founder's perspective, we take an example where you have 3 shareholders. Each of them own 33.3% of the company. One of those founding shareholders, after 10 months, decides that it wants to leave the company. Another one decides after a year and 2 months that it wants to leave the company. There was no vesting in those stock purchase agreements. You now have a founder who's stuck holding 33% of the company, doing all the work, needing to go raise capital, which means he's going to end up, or she, going to be diluted to 10%, 5%, 3% of the company, and really you're probably going to lose all motivation to actually do the work. Whereas if you have a vesting schedule in there, and the most typical one is going to be what you call kind of a 4-year vesting schedule with a 1-year cliff, which basically means you've got 25% of the shares that vest after 1 year, and then after that, you basically got every month the rest of the shares kind of being vested over the remaining period of time. If you've got that in place, you have the first 33% shareholder who leaves after 10 months. Well, that shareholder, the company repurchases those shares at the original purchase price, typically. And you now have the other 2 shareholders who own 50% of the company. And the next shareholder then leaves after a year and 2 months. That shareholder retains 12.5% of the entire shares plus whatever for that 2-month period, and they're holding 13, 14%. The other shareholder is holding 86 to 87% of the company. That motivation is still there to continue working, and it's logical and it's fair. The hard part is when your client tells you, but we're all friends and we all trust each other because I hope you're all starting companies with people you trust. They might not be friends, but at least you need to trust them. But that does not mean that you can just ignore the vesting issue. So what I just gave as an example is time-based vesting. You could also have performance-based vesting. It's not as typical in your founder stock purchase agreement to see that, but there are scenarios under which you might want to set milestones that need to be achieved for the shares to actually vest. And they could be actually achieving certain revenue targets, whatever it might be, but you don't see that as often. Another issue that comes up, and it's related to the vesting again, and you should have it in all stock purchase agreements that have vesting in it, is going to be the acceleration of that vesting period. And really what this comes down to is in a situation where the company is going to be purchased or you've got a shareholder who's going to be terminated, does that shareholder actually have the right to the shares that were not vested yet? And there's two ways of dealing with that. One of it is kind of a single trigger acceleration, and the other one is a double trigger acceleration. The double trigger is viewed much more favorably because it leads to less dilution by investors, and it is also more common. The single trigger, the way it works, is kind of one of two methods. The preferable one and the one you see most often is going to be upon a change of control. So for simplicity, let's just say if more than 50% of the equity in the company is sold, then those shares are going to vest, and the shareholder has a right to those shares without any vesting, not subject to any more vesting. The other possibility is the termination of the employment of that shareholder, but that's not very common. Now, double trigger acceleration occurs where you've got both a change of control and you've got a termination of employment. That termination could happen upon the change of control or within a specified period that sometimes goes out to 18 months post change of control. Again, that is going to be favorable from the perspective of, well, mostly any kind of investor that's coming in afterwards. Also, you're going to have transfer restrictions. Yes? Yeah, that is becoming more and more true from the founder's perspective, and that's because basically what you're seeing is a lot more sales of companies rather than something like an IPO. That being said, you do run into the situation where if you have a single trigger, you then have an investor that comes around afterwards and that is basically trying to renegotiate things with the founders. And that is not necessarily desirable. Now, as founders here, I'm not telling you that you want to necessarily have a double trigger acceleration provision in your stock purchase agreement. If you're negotiating it, I'm not sure that I would be looking for that. That being said, it all depends on the kind of money that you're looking to raise. Truth is, if you're going to go, in my opinion, if you're going to go to large VC firms and you're going to look to raise capital, I think you're going to have more trouble, although, again, it's not outcome determinative, but more trouble with a double acceleration provision. He does not agree with me, but we can agree to disagree on that one. Confidential information and invention assignment agreements are other agreements that are going to be entered into generally right when you form the company. And again, with essentially every founder, employee, and consultant that you end up bringing on. They're not going to be, generally they're not really argued with in terms of whether to enter them or not. And the reason is that you basically need to protect your confidential information, both from any founder, employer, consultant sharing it, and from actually using that information themselves. And then any invention that they come up with should be assigned to the company, and it makes sense if it's during the term of the employment. That being said, when you're dealing with founders, and sometimes this ends up being in your stock purchase agreement, sometimes it ends up being in the invention assignment agreement, but you're going to want any related IP to be assigned to the company at the time of incorporation, usually in consideration for the shares. And so the type of a lot of that's going to depend, I guess, on the circumstances. So you may actually often be in this case where you've come up with IP and you have not formed your company yet. And you want to make sure that the company actually owns that IP, especially if you have other founders who also have IP. You want to make sure the company owns that, because if you don't actually assign it to the company, they don't actually own the IP. It doesn't actually own the IP. Also, you're going to want employees, as well as founders and consultants, to basically agree that they haven't taken any IP from a foreigner company. That's just to leave your company out of hot water. Then you've got equity incentive plans. I find that these documents are often overcomplicated when they don't need to be. There's really two types of awards that I think you really need kind of upfront, and those are going to be stock options and restricted stock agreements. You often see stock appreciation rights in there, restricted stock units, especially in a early stage startup. Those really aren't necessary and overcomplicate the document. You also want your equity incentive plan to have flexibility for the board of directors. So if you have a vesting schedule, for example, set out in your equity incentive plan, you want the board of directors to be able to alter that vesting schedule. If they do not have the right to alter that, you're going to have issues trying to negotiate things with employees or consultants down the road. You're going to want to pay attention to the shares that are reserved in the equity incentive plan. So there's going to be a provision that basically says, this is the number of shares that can be issued pursuant to this plan. And there's numbers that are always thrown out there. Between 10% and 25 or 30% of your company should be set. But really, this is company that should be reserved for issuance. But that is a company-specific decision. But it's something you want to pay attention to whenever there's an equity incentive plan that's being adopted by the company up front. And then the board of directors must approve equity grants. One of the bigger mistakes that I've seen with companies is officers going ahead and issuing awards to companies, to employees. The officers don't actually technically have the right to do that. It's the board of directors that needs to do it. Now, Delaware made a change to the statute a couple of years ago to specifically deal with the fact that this happened all the time and there were issues in case law because of it. And they specifically said that as long as the board sets some sort of formula for the officer that it can just plug in, at that point in time, then the officer can be the one to actually grant the equity. So that's something that, as a company, you want to consider. That being said, it's usually good to have a board process in there when you're trying to figure out who's going to receive awards. So next one is I want to talk about is kind of capital raising options that you have. And I'm not going to go into it in depth at all. I could do an entire presentation on the capital raising process, but it's really just understanding the options that you have. And some of these are for earlier stage companies and some of them are for later stage companies. But one of them that's becoming more and more popular, well, really I can bring up two of them, is incubators and accelerators. And there are a huge amount of incubator and accelerator companies out there. Really the kind of big difference in my view between those two have to do with the stage of the company, and that incubators are usually going to have earlier stage companies, and the duration of those two programs. So incubators, you're usually going to be in there, well, I wouldn't even say there's a usually, but you're going to be in there probably longer than a year, probably under 2 years, but somewhere in between. Whereas an accelerator, you're going to be in there for generally a fixed period of time, 3 to sometimes as long as 6 months. And the goal in Accelerate is basically to accelerate your product development and your basically knowledge of kind of startup companies in general, capital raising process, and again, product development, bringing a product to the market faster. You've got research and industry grants, which are all very relevant to you in the medical device field, but there are a lot of those available, and it's something that should be looked into because that does not cause dilution the way other type of capital and any other type of capital raising does. You've got friends and family rounds that are, again, another way of raising capital. I just caution everybody in doing that, and the reason is usually you're raising small amounts of capital with a lot of investors, and usually you're not complying with securities laws at all. And there's just a lot of issues there in terms of not complying with securities law, A, and 2, having a ton of investors. It's actually problematic given the rights that you have as a stockholder or any stockholder has in terms of whether it's informational rights or other rights that a stockholder might have when you have many of them and can cause problems for a company. The next source is crowdfunding. As I'm sure you've all heard, kind of new crowdfunding regulations came in about a year ago now. And the big thing there is just to know that they're not as useful as people thought that it would be. You've got certain I guess, restrictions that make it a lot more difficult to raise capital and limit the amount of capital that you can raise in crowdfunding. Next one is angel investors, which you're typically going to run into them, kind of your seed round, although there's a lot of angel investors as well as angel groups that are coming in at later rounds as well. And they're basically people that have money and that are willing to invest in your company. It doesn't mean that it's necessarily an easier process than when you're dealing with venture capital firms. It's generally actually a more time-consuming process. They're going to want to do due diligence, just like the venture capital firm is going to want to be doing due diligence. But they are a source of funds that are available. And the next one is venture capital, as I mentioned, which is kind of typical. The first thing that people think of in terms of raising funds is venture capital money, and that is a good source, but it's not necessarily easy to attain. The last one is public markets. That's obviously a lot later stage. You're seeing a lot less exits into the public markets, but it is a opportunity. That's all I have. Elliot, do we have time for questions, or should I take them after all the presentations? There's one over there.
Mark?
Yes.
There you go. It's on. The only thing I would add to your last slide as far as sources of capital, in the last 5 years, especially the last 2 years, investment bankers, particularly in Manhattan, have really started to move into the early stage venture-based financing. You have investment bankers such as Spencer Trask in New York that really do early stage, and they take their fee later. So they're competing with the VCs in that early space. So that's a good source for many people to know.
Agreed. Thanks.
Well, there's no more questions. Thank you. Let's thank Mark.
Thank you.
There's going to be time, a good maybe 20 minutes or so after the session, if you want to ask Mark questions in person. So can we bring up Bill's talk, please? The next speaker is Bill Shaw, also of Rattan and Tucker, and he's going to speak about building up an intellectual property,
Something like that, yeah. Love the one, thanks. Good afternoon, my name is Bill Shaw. I'm with Rattan and Tucker. The firm's been around 100 years. I've been with the firm for a year and a half, so a little difference. What we'll be doing and discussing is the creation of assets through intellectual property. The roadmap for this will be maybe the first 8 minutes. We'll describe intellectual property, what it is, make sure everyone's on a level playing field. Then I want to jump to mistakes that I've seen in my practice for the last 20 years of what young companies and also entrepreneurs make certain mistakes that can be corrected, but if you can avoid them now, that's the best time. I'd like to also thank UCI and Elliot for getting the presentation together. I appreciate it. We were really excited about trying to help out the young companies to be successful. So first of all, what is intellectual property? Intellectual property is really 5 rights: patents, trademarks, copyrights, trade secrets, and trade dress. Now, if I try to group it, I'd group patents and trade secrets as a way in which you can protect your inventions through either public disclosure of the invention, vis-a-vis trying to obtain a patent, or having some internal procedures in place in which you can protect your secrets or your confidential information through trade secrets. The other grouping I would make would be trademarks and trade dress. This is a way in which you're protecting your goodwill, your customer relation. What you're trying to do is you're trying to avoid customer confusion through use of marks, certain brands, certain ways in which you present your company. Last one is copyrights. Copyrights, another property right. What you're protecting is the expression of your work. And I'll give you an example. If you're a coder, you're coding the information, you get your program together, you are the copyright holder. What are you protecting? You're not protecting the functionality of your code, you're protecting the expression, the certain procedures that you're using, the interrelations between the modules, the loops that you're doing. That is the expression that you're protecting. So all of these make up intellectual property. Now, we're going to jump into and focus on patents in particular because that's kind of the vogue in which young companies, they think the most value is going to come out of if they start pursuing patents. So the question is, what is a patent? The short answer, it's a legal monopoly. The long answer, it's a legal document that confers to its owner, the patentee, the right to exclude others from making, using, selling, or distributing the claimed invention. And I highlight exclude because the patents don't give you the right to do anything. It gives you the right to prevent others from doing things and practicing your invention. It operates as an asset for your company. It can be sold or licensed. It can also be used as collateral for banks. That only applies not only to patents, but also your applications as well. So knowing that, let's jump and dig down a little deeper the types of patents. There are two types, utility and design. Utility, what you're protecting is the architecture or the functionality of your device, medical device. The term is 20 years from the date of your effective filing date. And I'll give you an example. You file an application. It takes 3 years to get your patent. Your term is 17 years. So it takes you 2.5, it's 17.5. Design patents are a little different. You're not protecting the architecture, the functionality. You're protecting the appearance, the non-functional nature, ornamental nature of your invention. The term is 14 years from the date of issue. Now, I get questions, why are these terms different? Why aren't they just the same? The idea was about 20 years ago, the strategy for a lot of patent applications was you filed the application, you kept it buried. In other words, the technology wasn't mature yet, so you kept it in the patent office until the patent started mature, the technology started to grasp hold in the market, and then you got your patent. It was called a submarine patent. Lemelson, another one was a Lemelson patent. He had a patent, believe it or not, on a processor and brought these things up and sold it and made hundreds of millions of dollars through licensing. So statutorily, they said, we're not going to have any more submarine patents. We're going to put the term for utility at 20 years from the effective filing date. Now, breaking down utilities, there's 3 different paths you can take. And I think you probably may have all experienced this. But provisional, what it does, the purpose is to give you a filing date on disclosed content. That's it. It's not examined. It goes abandoned after 1 year, but allows you the ability to get your ideas or your concepts into the patent office. No format requirements. You can file slides. You can file a paper if you're going to disclose something in a conference. So the format's not really important. I highly suggest that you file it as an application, but sometimes you're rushed and you don't have the ability to do that. There's no format requirement. The other thing for protection, as I said, there isn't any. What you are able to do is you're able to use US patent pending on your products or on your services if you have a website. You're also able to use that date as a priority date in your non-provisional application, which we'll jump to. The non-provisional application is what we refer to as utility patents. That's the purposes you're trying to get patent protection. That's examined by the examiners. That's the one that you will try to obtain the patent protection that you're trying to achieve. Format, they have a set format. You got specification, which has text and drawings. You have at least one claim. You have an abstract as well. The protection, I want to repeat, is that the protection is afforded based on the scope of the claims. And I want to say that again. It's on the scope of the claims in which you're getting the patent protection. And I'll jump to that as why that's important at a later time on the other side. But in the other path you can use is what's called PCT application, Patent Cooperative Treaty. It's a way in which you can file an application and then you're able to go into the US and also into other countries by just this one application. So those are the paths in which you can get a utility patent. Jumping to design patents, it's a little different. As I said, with utility, you're trying to protect yourself through the scope of the claims. Design, you're protecting yourself through the drawings that you're providing. What the standard is for design infringement of a design patent is that is accused device substantially the same as the patented design. And I'll bring up a patent for flow track, which is basically a sensor. But if you look at the shape of it, what you're looking to see is that shape exactly the same as the flow track. So you're looking at, as compared with curvatures, you're looking at the trough, you're looking at the curvature of the inlet and the outlet. So that's where people look at to whether or not you infringe a design patent. In summary, the difference is that utility, 20 years effective filing date, 2 to 4 years it takes to get a patent normally, and this is the protection. Design is 14 years from the date of issue, 1 to 2 years it mostly takes. Provisionals, no protection. What you're given is 1 year to convert it to a non-provisional application, in other words, the utility application. No searches get done on the provisional. That's an important thing to know as well. You file it, nothing happens. They put it on a shelf, wait for you to file a non-provisional in the PCT application. So now everyone's on the same kind of playing field and they know the layouts for patents. So let's jump to 5 tips to avoid for patent mistakes. I think those are the people that can get the patent. Now it's a first to file. So if you spent 3 years designing and developing your invention and you file an application, but someone only took 2 months to file it and file the application before you, they're going to get the patent and you will not. So it's important to know that you cannot delay. And there's also no requirements to reduce it to practice. You can file it before your invention's done. You just got to file it when you have a good sense of the core concepts. So the solution, file a provisional, non-provisional application when the core inventions are completed. And I'll give you an example. This is when you should file. Normally you have a problem and people figure out a solution. And then, for instance, for this group, you're going to maybe develop a medical device, you may figure out marketing, how to get the name out, and then you start selling the product. People think, I'm selling the product, if the product's doing well, I'm going to file when I sell the product. Mistake. You may lose your foreign filing protection because most countries require absolute novelty, which means there cannot be disclosure before you file your application. There are exceptions, but that's the general rule. Also for US, if you publicly disclose your invention, and after a year you decide to file your application, you may be precluded from pursuing that invention. Then people say, well, maybe I'll file it when I finish the medical device. Well, that's probably not a good idea either because you've already spent a lot of time developing it, and you really haven't figured out, maybe it's when I figure out the solution, when I figure out the core invention, and when I completed that, that's when I should probably start to investigate filing an application because the main concepts are down and you can now develop your application based on that. The second thing I see is that don't disclose your invention publicly prior to the filing of your patent application. I saw the NDAs that went around, great idea, that's non-disclosure. That's the right thing to do when you're going to disclose some information about your invention. The fear is that if you disclose it, there's a potential loss in foreign filing rights. As I said, most countries around the world have an absolute novelty requirement. The US does not, but say for instance, Europe does. Also, when you disclose your invention, it encourages the creation of prior art. In other words, other people talking about your inventions. And that, believe it or not, can be used to preclude you from getting a patent because someone may be describing your invention in such detail that it will be found by the examiner and it could preclude you from obtaining proper coverage. And last is loss of all IP rights. You disclose it, you wait a couple years, you decide to file, you may be precluded from pursuing that particular invention. Now, don't lose hope. Sometimes people disclose things and then they develop additional inventive concepts down the road. You may be able to still pursue those, so don't give up all hope, but that's when you need to discuss it with your patent attorney, you need to discuss it with your UCI personnel to figure out, is there still some viable inventive concepts that I can pursue? The third item here is determining inventorship and ownership early in the process. Now, we have a struggle, and even I have it now, it's a struggle of who are inventors. The inventors are the people who conceive the idea. You may have a group of 8 people working on something, but it's the inventor is the person that conceived the idea, not the person that may have worked on code or helped to reduce it to practice. So we need to remember that when we're doing the application, and that's a good thing to kind of think about when you're filing the application or getting ready for filing. The second point is inventors are de facto owners of the patent. Without any change, if two people, you and your buddy, are filing an application, you both are owners of the patent. That's important because if the patent does issue, then what you're going to have is you're going to have the ability of both parties to license it without permission of the other person. So it's always good when you have multiple inventors to get it into one single entity. I mentioned about de facto owners. There are ways to adjust the rights for the US patents. One is, for instance, assignments are done. Licenses, you can get ownership of patents from another group to utilize their technology through exclusive and non-exclusive. Also, when you set up a company and you have your employment agreements or offer letters, as Mark was saying, that you may have offer letters in place, that you may want to make sure there's assignments of property rights, make sure that's really clear in the offer letter or the employment agreement. And if you don't have that, there's also the shop right, where that's basically an interesting legal avenue in which you don't have an employment agreement, you don't have an assignment in place, but the person utilizes your company services, they utilize your resources. That may be a shop called a shop right, in which you get a non-exclusive, non-royalty license from that person. The fourth tip is don't forget that you need some foreign filing license if you're going to file out of the country. And I see this happening quite frequently in that people, when they figure out an invention, they want to file an application, they want to file it in the best market, which may be, say, for instance, Australia. Well, you need a foreign filing license to do that. You can't file directly into Australia. You have to get a permission from the United States, especially if the invention was made in the United States. You need to get permission from the United States to file the application in Australia directly. So if you're working collaboratively with another person in another country and you decide to file an application, one of the topics would be saying, where do I want to file and how do I protect that person in the other country? And I'll give you an example. I had a situation where it was a US inventor and an inventor in India. They were both collaborating, both developed the inventions. How do we handle this? Well, we had to get a permission in India from the Indian Patent Office, permission to foreign file in the United States. If you don't do that, it's by, I think it's 35 USC 186, it's statutory, where you could be fined $10,000 and you could be 2 years in jail. That only happens, and rest assured, it only happens if it's a national secret. That's where they kind of look to see, because every application you file, they evaluate the subject matter and they say, is this a nation secret that we need to preserve, in which case they'll give a secrecy order and that prevents you from filing the application. In my 20-some years, I've never seen it. I've heard one story about it. So it mostly happens when it's something that is, for instance, an armament or something that involves nuclear capabilities. The last thing, and probably the second most important thing besides don't delay, is understand the content of your application, both the specifications and the claims. Now, for design patents, what you need to understand is what's the coverage? I mean, I have drawings in the application. Isn't that the coverage? That is true. But with drawings, there are certain aspects of the drawings that you may think are not really patentable, and I may not want to require someone to follow, in which case you can have the draftsperson dash line it, in which case it's an optional feature. So you need to understand, for at least design application, what are the really important and creative aspects that I want to make sure are covered. And then the other material I may not want to have in my design patent, I may want to have it dash lined as an optional feature. I think the most critical is for utility. What do you need to know? And what do you need to make sure that you have? I think that you need to make sure to look for in your specification is, I need multiple embodiments. Not only to capture my invention, but also anticipated design arounds. My first question I ask inventors is, tell me about your invention. They describe it. My second question is, Given that information, how would you accomplish what you're going to do through another design? And they say, well, instead of doing ABC, I do XYZ. There's your alternative embodiments. Capture that in your application. Now you have a better application and perhaps better coverage than what you decided on before. The second thing is make sure your specification is complete and be mindful of the trade secrets. Sometimes people have code that they want to preserve or certain trade secrets and they accidentally put it in the application. It's gone. Also, the use of generic terms. Some people want to be specific. I want to make sure I talk about a certain type of register for memory. Well, maybe instead of register, maybe call it a data storage. Or maybe if you want to have it a volatile memory or non-volatile memory, call it by that. But don't go to the specific terms yet. If you want to capture a specific term, use E period, G period, comma, and then put it out. But try to use generic terms because it gives a broader coverage at the end. Also, you need to understand, and it's really important that people forget, you need to understand the claim coverage and the claim strategy. People rely on your patent attorneys to do this, and I think that in some cases it makes sense, but some cases I think you need to ask that next question, does it cover more than what my invention is? And I'll give you an example. Say we're back in 4000 BC. I'm writing on my tablet and my arm is killing me. And I say, boy, I need to figure out something to make it easier to write. So I come up with an idea. How about a table? Pretty simple concept, technology rise. So I call my patent attorney, I say, hey, can you write an application for me? So he writes it, and remember I talked about the claims being the protection. Here's the claim that I have. Rectangular piece of wood and 4 legs oriented perpendicular to the rectangular piece of wood and coupled to the corners of the rectangular piece of wood. That's accurate. I look at it, I'm the inventor, I say, that's exactly what my invention is. That's great. But with any claims, you have to think, is it accurate? And are you anticipating what could be the next change? So 2.5 years later, I see this pop up. And I go, well, hold it, let's go back to let's assume for patent infringement. Remember, for patent infringement, you have to infringe each and every element of your independent claim. That's each and every element of your independent claim. So I go to the patent attorney. Do they infringe? Not quite. First of all, it's not a rectangular piece of wood. It's circular. There's no 4 legs, there's 3. And by the way, the legs are not perpendicular. They're oriented at an angle. And by definition, since it's circular, there's no corners, so you can't infringe on that. Okay, so the competition comes out with another one. Oh, there's a pedestal too. I can go after this, right? Wrong. Forgot the wood. This is a glass top. 4 legs? No, I argue it's 2. And by the way, it's not on the corners either. I can go out all day on this. Pedestal. No, wrong. So the idea is that when you're doing an application and you're doing your invention, whatever the invention is, think outside the box, think of the next evolution of the product. If you can. I know it's really a lot to ask, but that's also for your patent attorney to approach it as well. Say, what about this? And if you thought about it, you would have said, well, how will we have this claim that says a first element include a top surface and a bottom surface, and a second element include a top surface, the second top surface being coupled to the portion of the bottom surface and having an area less than the entire area. Yeah, there's even problems with this. I'd say, if I was looking at it, do you need a top surface and bottom surface? How about a first and second surface? Could the legs come on the side? That's stuff that you guys need to talk about. And we always forget to talk with our patent attorneys about the claims. We look at the spec, we look at the text, we look at the drawings. Is it all accurate? Yes. The next step is, by the way, what's this? Ask the question, what does this claim cover? So we spent about a little time, 20-some minutes, talking about the strategies. Now, at this stage, does anyone have any questions about patents or anything? Yeah.
So with regards to the patent being generic, easier. So with regards to being generic in your patent, so for example, let's say I'm developing something that uses speaker, but instead of writing speaker, I'm going to say sound producing device in my claims. But sound producing device could be a loudspeaker, it could be an earphone, right?
Right.
So then is it risky in writing sound producing device in that somebody comes up with an invention and they use a loudspeaker, so they can claim, well, we're more detailed, we're talking about a loudspeaker, and therefore, you know, they can produce a patent that's offshooting yours, or is it better to stick with that generic name?
I think it's better to stick with the generic, and let me explain why. First of all, let's give the example of what you said. I'll call it an audio device versus a loudspeaker, right? When examiners examine the applications for patentability, they look only at the claims, right? So if my claim talks about a audio device, I don't care if you said it's an earphone, it's a micro, maybe it's a mic, well, it depends, it's emitting, it wouldn't be a microphone, but if it's a speaker, it's an earpiece, it can be a loudspeaker, it doesn't matter. The examiners will look at the term and say audio device, that will capture the invention. Now, if you're concerned about it, you say, now the use of this loudspeaker is really important. I'd say go with the audio device, but there's other claims that are called dependent claims. They're the claims that depend on the independent claims you imagine. So I guess it augments your claim. In your dependent claim, you can say the audio device is a loudspeaker. So the dependent claim, in essence, would have all the elements of your independent claim, but define your audio device as your loudspeaker. Does that make sense?
Yeah, so then essentially, if somebody wants to, you know, argue against it, they're going to look at the independent claims, but if you specified with dependent, you're essentially securing yourself.
Yeah, what would happen is you'd argue that you'd infringe with the audio device and it had all the elements, they'd infringe the claim. Now, they'd argue maybe invalidity and bring something up. That's where they'll have to go to the dependent claims and say, is it invalid if it was a loudspeaker instead of another type of device? So I think you'd cover the infringement, but you'd also augment it and try to avoid invalidity challenges that people will make down the road. Okay.
Thanks so much. Can you comment a little bit more on inventorship and the order of names? Is there a way to, maybe if somebody had a very small contribution, but it was still important to name them as like a 5% inventor?
Right. What I would do is, well, what we normally do, it's not a written rule, but it's kind of like a practice, is that, first of all, I determine who conceived the ideas. So if there's a group of 5, all of them contributed to the claimed invention. Remember, we don't really know until, we have kind of a group, until we get the claims down, and then we figure out who are the inventors for these claimed subject matter. All 5 people, the standard rule is, my view, whoever works with me on doing the patent, they're number 1 because they invested the most time. And then it goes down the chain. So that's what people have mostly agreed upon, at least in the industry, because if they're the people that are the lead, they're mostly the most actively involved in it, and they're also investing the most time. So we make them as the number 1. And everyone else, we kind of go by kind of pecking order, how much they contributed.
But that doesn't change the fact
It
that
does.
everybody owns.
Everyone is an inventor. You can search it. Like for instance, I'm an inventor. I'm the 3rd inventor on a customized wheelchair. My son, who designed it, really, he's like 10 when he came up with the idea. He is the primary inventor because he came up with the idea.
Elliot, my question is on the business side. I think it was on your first or second slide.
Okay.
You referred to the collateral use of patents. I remember in my last startup, you know, we went to SVB amongst others, Silicon Valley Bank, and the experience that I've had directly and also through other serial entrepreneurs is the collateralization of patents. It's really sort of an ancillary thing. I've rarely ever seen any sort of loan or financing extended because of, and this is in spite of independent opinion of counsel or what have you on the validity and what have you of the patent. So this is really like a business question to you. In your 27 years of practice, to what extent have you seen patents being used as collateral? It's usually in the holistic concept of a business that they've been used.
Right, and I agree with you. But matter of fact, within the last month, we had someone use a patent application as collateral for a loan. Yeah, it was a diamond, basically a diamond, a jewelry company that's using the how to analyze the diamond as collateral for their loan. But it does not happen very much. I'd agree with you. It's very usual. A lot of times these patents are used as a defensive mechanism or offensive mechanism. Mostly it's used for a business to keep people away from being sued for patent infringement for their products. If I have more time, I can go into some trademarks if you want to talk about them. Healthy 5 minutes. Let's jump. Hey, no. Trade dress. I can talk about trade dress a little bit, but I got some slides. But trade dress is the way in which you're trying to protect certain packaging. I'll get to that maybe a little bit here. Sorry, I'm get to where I was before. Okay, we'll go to trademarks and then maybe we'll get into trade dress a little bit. Trademark, source identifier. What you're doing is protecting consumers. You're not protecting yourself, but you are establishing goodwill between your customers. You're distinguishing products and services between the companies. That's the goal behind these. Also, you're signifying implicitly the quality of your goods. Types of trademarks, 4 types: word, design, combination, sound, color, device. Word marks. 3M, Yahoo, certain examples. Obviously, people argue that whether or not there's a design here, but slogans. Just do it. People think of Nike, Eat Fresh, Subway, Like a Good Neighbor, They Farm. Design marks. There's no words, it's just a design. But you look at these, you're able to identify what the source is. Combinations, it's a combination of design and the word. For instance, Goodyear, you look at the Mercury wings, that's really a combination mark. Sound marks, listen. Oh, gosh, it didn't sound like, wow, it didn't go to sound. It goes dun, 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 dun. That was Intel Corporation. That didn't work. Color, some shoe. Acquired distinctiveness by use. It can't be functional. This is my favorite. Design marks. It has a similar thing to trade dress. You're protecting the certain feature or design, some packaging of something. It also has to be non-functional. Now, my wife and my daughter, I'm not exaggerating, within 3 seconds they picked this. I still to this day can barely figure it out. But here's the design mark. Can anyone tell me what this is? You blew it. This is a chocolate bar. Believe it or not, Hershey has a design on the chocolate bar. You believe it or not, another thing is Klondike bars. You know the packaging, the silver packaging? That is that's again trade dress. You're protecting the look of something so that consumers, when they see something, they realize this is the maker of it. That's what these design trademarks, service marks, trade dress is all about. It's about identifying who the source of the product is. Tips to avoid, do quickly. When you're doing a mark, conduct some searches. As patent attorneys, we have professional searchers that we have to do it. We don't do it, matter of fact. But you can also go on the USPTO website. It's uspto.gov. You can search their registered marks. You can search pending marks. You can go Google your design. There's a lot of different There's a lot of different ways you can search. Also, people have made mistakes when they do decide to register a mark. They select the wrong class. Believe it, I think there's 45 or 46 different trademark classes. If I was in a medical device, you'd say, well, that's class 9. That's electrical devices. Well, but there's class 10. There's medical supplies. There's class, I don't think it's 38, which is some other service that it provides. So you have to pick the right class. And I'll give you an example. When I started a long time ago, I took a trademark application, a trademark registration from a client. They got a trademark on a name, and it was for T-shirts. And they said, well, we're going to expand the clothing line. And I looked at it, and I said, well, you need to file another trademark application. I said, why? Because they said, yeah, your description of goods is trademarks. And that's the third thing, is that when you define your description of goods, you try to be broad. If you go very specific and you decide to expand your line of product, your application will not comply, in which case you'll have to do another application. So it's always good to think, where am I now, where am I going? Same thing with patents. Where is the product now, where am I going with the product? Those are good lessons to learn when you're starting to do patent applications and trademark applications. So I think I've used up all my time, but any other questions before I pass the reins here? Okay, thanks. Thank you. Yeah, please.
I have to. You guys turn on radio. Great. I've actually heard that talk hiking twice now. It was great. I like it with the visuals.
Yeah, the visuals are much better.
So again, I want to thank Mark and Bill for donating their time here. They do tend to hang around, and if anyone here would like me to put yourself in contact, this is not, I swear I'm not paid for this, but they were very interested in working with UC entrepreneurs. So if you'd like to be in contact with them, just shoot me an email. And I think also, part of the CAI's mission is education. And I can ensure we're going to ask you guys to come back in continuing series and maybe some webcast series. This is very important stuff for what we're trying to accomplish. And now it's really my pleasure to introduce our keynote speaker. Ray Cohen is currently the CEO of Exonics, which is this really fantastic, I would call, transformative device for regaining urine and fecal control, which is obviously a very big problem. I have met Ray. Originally, we shared a parking lot back when my company Metronome was first founded, and Ray was with Vesix, which is maybe a couple hundred yards away, and I looked up to this guy. It was 7 years ago. I was younger. But Ray is so inspirational, and really the story he's going to tell you is what everyone here wants to experience if you haven't experienced it yet. And I'm really grateful for you taking the time, and let's welcome Ray.
Thank you. So thanks for inviting me. I'm happy to be here and tell a couple stories. Before I get started, I want to acknowledge the gentleman from Rutan. I think that was really excellent information that you're providing, very, very useful information. I only have one comment about IP that I want to make, I think, and that is that it's very important to focus initially on freedom to operate. The whole conversation was about patents and how do you get patents and what's involved in those, but more importantly is the ability to be able to practice your invention, and the way you get to determine whether you can practice that invention is to do the work, to look at the field, to look at prior art, to look at patents that are either issued or in application form, so that you have a sense that you can actually do the work that you need to do. And if you're looking to raise money, I can tell you that don't get tripped up on saying, well, we have these great inventions and I have these patent applications or provisionals or whatever. And then the question from any investor is going to be, so tell me about your freedom to operate analysis that you did. And then the answer is, what do you mean? That's the problem. So I'll give you that piece of advice. So I'm going to tell a little bit of a story about a company called Vesix Vascular that we were successful in raising some capital, pivoting in a company, and then actually getting it sold. And all this happened within a 2-year span of time. So I would tell you that it's a wonderful thing if you can actually pull that off. And it's taken, for me, it took a lifetime of projects and trial and error and lots of different twists and turns along the way. So I found this quote the other day. I thought it was really interesting, and in a way it tells a bit of the story of Vesix, and it tells the story of my whole career. I've been in the medical device business now for 35 years. I've been in all kinds of different products and technologies. As Elliot mentioned, I currently serve as the CEO of a venture-backed company that's raised $60 million with a neuromodulation play, and we've done that in less than 2 years. And that company has a product that's now completed, and is in clinical study, and actually we're in the process of an auction to sell the company. And that'll be 3 years from the start of this project, almost to the day. So that's the idea. Once you've been in the game for a while and you've got scars on your back, you start to realize that, saving lives is great, helping people is great, but in the end of the day, it's, the scalps on the belt that really matter. And I can tell you getting an exit is the greatest single entree to raising capital, because people, like Donald says, people want to invest in winners. So, sorry. Go out and vote on November 8th for Hillary Clinton. Anyway, so the quote is, the pessimist complains about the wind, the optimist expects it to change, but the realist adjusts the sails. And ultimately, that's really the story of Essex, and is the story of every single project that I've been involved in my entire career. Not one project where we started did we ultimately end up with the product or embodiment or clinical application that we finished with. And I think that it's so important to read the tea leaves as you go along and to really constantly be looking, am I doing the right thing? Is this the right clinical application for this technology? Is there a better clinical application for this technology, et cetera? So just to start, the silly cartoon, right? People are the most important asset, but of course, if you don't have money, it's hard to potentiate any idea. So luck always favors the well-funded, and you got to be brave, and you got to be good, you got to be smart, you got to be all those things. But what are the elements of a project? And I think it's really critical that if you're going to spend your time and money and time and energy as an entrepreneur, and I'm speaking mainly to entrepreneurs in the room, pick something that at least has a big market. An incremental idea, a small idea could improve something, could improve a gadget, that's great. But if you expect to be able to raise capital, you're going to need a big opportunity, you're going to need a big market. So that's the first filter in my mind is, how big is this market? And have you done the real work necessary to determine whether or not, there's a real market there? And secondarily, it's better if you pick a market that actually exists as opposed to one that could exist in the future. There's a lot of inventions today about people taking control over their own health care and all this great information that you can get from all these gadgets. But the reality is, who's going to pay for it? Nobody's figured out the paradigm yet. And it's going to be difficult to pitch that idea if there isn't an existing market. I've boiled that down to, it's just better to be a fast follower, So there's a lot of opportunities. People come out with something that's really, innovative, but typically the first product in a particular clinical application is not an embodiment that is ultimately the winning embodiment. People sometimes rush their stuff to the market, if you may, or rush it to the clinic. But my philosophy is you should never go do a clinical study with a prototype. It should be with a commercial product. So put yourself in a position to win the game. Design research input. I'm amazed at how many people just skip right over this. We've got this idea, we're going to start designing circuits, and we're going to start to make a prototype, and I've got to get a prototype because if I can't have a prototype, I don't have proof of concept, I can't pitch my idea, I can't do this, I can't do that. And they forgot about market research, they forgot about design in research. What does that mean? Well, how are people going to use and interface with your product? What are the people who are living and wearing or have these implanted devices or whatever it is? How do they interface with this kind of product or concept? If it's a new idea, then go to an adjacent idea or adjacent market or adjacent product, and you can learn a lot. And this is really what industrial design now has turned into, is the front end of industrial design is no longer just pretty pictures and pretty shapes and all that, but it's the research that happens up front. And if you do some disciplined design research, it'll inform you on how to actually design your product. Because you'll know what people like, what they don't like, whether it's physicians, nurses, patients, whatever the case might be. I could spend 2 hours just talking about the importance of design research. It's not cheap. You have to spend money. Okay, everything is about, in the end, you need the money, but it's an important piece. Second is physician input. I'm shocked to this day I get involved in companies that have not formalized the medical advisory board. You know, if you're in the medical business and you're in the device business, which I assume the focus here is not pharma but device, right? So you got to get docs involved, and they love to be involved with industry. They absolutely love it, and you don't need to give them stock in your company. You know, they're happy to, for an honorarium, to come in a meeting with other colleagues. So, you know, it costs you a minimal amount of money, or you can go to them and sit down and get their input. It's really important. You know, all these good inventions, for the most part, a lot of them come from physicians and nurses and people who are aligned in the field, you know. So that's really critical, and that's going to be very important because all this is a setup, right? If you've done the freedom to operate work, okay, I have an idea, can I practice my invention? If you've done the design research, if you've done the market research, you know, if you've got your physicians who are a part of a team now and you're all aligned, well, you've set yourself up to be able to be in a position to be successful and ultimately exit your company, assuming that's your goal. Now, maybe if you've never produced anything and, you know, you want to make stuff and sell stuff and, you know, have a lot of pain and suffering in your life, then, you know, then don't do any of these things. So one of my other favorite lines is, you know, great in technology, it doesn't invent itself. You know, it just doesn't happen, right? You need people. And, you know, you have to have the right people with all the skills. And, you know, it's difficult to do it in isolation, one or two people working in a room. You know, you need a team. You know, teams generate different ideas and the collaborative nature of those teams. So it really is about good people. And, you know, if you want the best athletes, you know, once again, back to the money, right? If you want a good athlete, you know, on your team, you have to pay them. So there's that, right? So, you know, you can see there's a theme running through this presentation, and it is about the money. But nevertheless, these are true things. The other piece of the puzzle is clarity of purpose. I mean, truer words have never been spoken. You know, if you want to provide leadership to people, you have to be super clear about what the mission is. Very clear about the mission, and hammer that every single day. You've got to be really committed to the mission and not go off into different directions. There's a lot of opportunities for distraction when you're doing a project, you know. I see people chase variants of their ideas all the time, and they lose track of the primary mission. So those are my kind of big picture comments, and I'll close with some other ideas that may apply more generally. So I'm going to tell a little bit of story, a bit of a story about a company that I got involved in, which was not focused on hypertension. We pivoted to this particular application. So anyway, everybody knows hypertension is a big deal. You know, millions and millions of people around the world. We got involved in a project which is now referred to as renal denervation. It's a device treatment for hypertension. It's the idea of taking a catheter with an energy-based catheter attached to an RF generator, placing it into the renal artery, modulating the nerve activity in that renal artery, which sends the appropriate signals to the brain and reduces blood pressure. It really does work, and it works quite well. So the technology was originally developed, and it was focused on using this apparatus, if you may, to treat peripheral artery disease. Okay, now the company had a great idea, raised a bunch of money, went and did some clinical work, but it just didn't pan out. Okay, and after 6 years, the investors got fatigued, and they considered that, you know, they just decided that we should just shut this thing down. And that's when I got a call to say, hey, would you go in, take a look at this? It's a failed project. You know, should I keep it? Is there something else can be done with the technology, or should we just shut it down? So I got involved in the middle of 2010 in that situation. So, you know, I didn't really know what to do. So I figured, well, why not go and talk to a bunch of physicians? So the company had some relationships. I had some relationships of my own. I went around the United States. I sat down. I took half a dozen, 7, 8 meetings, whatever it was. And I said, look, here's the technology. Here's the current application. Hey, what do you think could be done with a technology like this? And sure as hell, during that, you know, trip, if you may, the idea of renal denervation came to pass. And I was like, that's really interesting. Let's go do some homework on that. So we decided to pivot the company. We got some funding for a transition to move the company to Irvine, brought an experienced team of engineers into the project, which have been my secret weapon because these are folks that I've been working with now for over 2 decades, and so have a good, solid group of people who know what they're doing. And we went about the business of developing taking this technology, pivoting it to a new clinical application. And lo and behold, a little bit of luck, because the predecessor, the company who actually came up with the first embodiment, got sold to Medtronic for a big number. Now, if that doesn't focus your mind, I don't know what will. So we were like, okay, this is a great decision that we made. Now we need to execute. So we went out and raised $27 million in capital from US and European investors and envisioned a second-generation product, a better embodiment, a faster procedure, and then figuring out what did we need to do to be able to make this product really special. Did the design work up front, did the research, did all the work that was necessary to inform the design of the product. And my thing that people joke about, but I said, look, here's the reaction I want when people come up to this device. The first thing out of their mouth is I want them to say, wow. And the next thing they would say is, that really looks cool. So, if you have something that has that wow factor, it helps a lot because it's the first impression that people, come to. And anybody who's skilled in marketing probably knows about first impressions and all that kind of stuff, right? All the consumer companies work on that basis. So in any event, we did the work and we figured things out, and we created a commercial version of the product in record time. And this is what the RF generator looked like on the left side and the catheter on the right side. Really unique looking product, very, very simple, and kind of had that Apple-like feel, which I think is important today in products. And we really had a fast therapy, significantly faster than what the first embodiment in the market for Medtronic was. Okay, so cool product and all the rest. So we went about the notion of gaining a CE mark for the product. Of course, one needs a quality system, and the people who understand what that means to be able to get a CE mark, right? That's a whole dissertation by itself. We did a pilot clinical study. We went out to Wall Street analysts. This was interesting, right? Private venture-backed company, but we actually went out and told the story to Wall Street on the basis that, hey, this is a great product, great technology, great opportunity, big market. We might want to take this company public. Well, all the analysts want to talk to you about that because they're looking for kind of fresh ideas, and they want to be informed and all the rest. And they're always covering somebody else. So in this case, anybody who covers Medtronic is interested to hear a story about a company that's a potential threat to a business that they recently purchased. So that was interesting. So we got a little bit of play on that. And they began talking about the company and the technology. So that was fantastic. And who were they talking to about it? Well, the same potential buyers that we want to talk to, right? All the big players in the medical device business. And I always look at them as in fact, those are my customers. That's who I'm playing to all the time with a medical device, the buyers of the business. Who is going to buy your company? And that's the single most important question that you should answer for a potential investor before they ask the question, is to tell them, this is where my product fits, this is the clinical application, these are the players in this particular market, these are the potential buyers for this technology. That's what every angel investor or anybody else who writes a check wants to know. How are you going to monetize this invention? How are you going to monetize my investment, and how am I going to make money, and how long is this going to take? That's what everybody wants to know. Right? If anybody had a different kind of investor who's not interested in a return on their investment, if you had, raise your hand. Nobody. Okay. So, sorry, trying to lighten it up, Elliot. It's a tough group. You got 2 lawyers in front of me, and it's like, come on, killing me. All right. So, anyway, end of the story is we had all the stars lining up for us. We had a great product, proved that it worked in a clinical study, and then did a bake-off of bankers, selected one. In this case, Goldman Sachs was interested in representing the company. We selected Goldman Sachs because my mom told me that it might be a good idea once in my career to use Goldman Sachs because everybody knows that name. Turned out to be a really bad decision, but nevertheless, we showed our product publicly. We invited potential buyers, the big strategic players in the market, Medtronic, Boston Scientific, et cetera, et cetera, et cetera. And we got the game started. We started in June of 2012, just 2 years after we raised the capital. We had a bunch of people interested. They got into phase one. We went through the process of bringing them to opportunity to see live procedures, talk to the key opinion leaders that we've been working with. Ultimately, we got it down to 3 bidders, and we facilitated due diligence. And then Boston Scientific, made an offer we thought was appropriate. We gave him exclusive rights. We negotiated the deal, and then in November of 2012, we sold the company in a transaction that had a value of $425 million, $200 million in cash, and the rest of it were on contingent rights based upon milestones. Now, the end of this particular story is, and the reason why I'm still in a suit, is that we got the $200 million, and that was great, and everybody made money, and Mama got some new shoes and all that good stuff. But Medtronic ran a pivotal study on renal denervation, and they had a really shitty protocol, and they screwed it up, and they didn't hit their endpoint. And so here we were expecting, this was $100 million revenue just in Europe, and we thought, wow, our deal structured was we got every single dollar that Boston Scientific would have generated for 3 years. Every dollar in revenue was going to come to our shareholders. And then Medtronic screwed up their study, and the $100 million market, instead of going to $1 billion and multiple billions, just the bottom has fallen out of it. And now they're back in clinical study work. Boston's with our product in clinical study work, Medtronic's. And so instead of getting $220 million more, we wound up with maybe, $10 million more, So that kind of sucked, so I went back to work. Okay. So, but we're at it again with another great project and hoping to get an exit. So in any event, I'd love for there to be some questions and so that we can have a bit of a conversation here. But these are kind of my parting shots, if it's not a big idea, then unless you're just practicing, then why bother, Otherwise, you're going to have trouble to raise the capital to do the things that you really need to do. Wall Street, I've been a CEO of a publicly traded company, so maybe I have a little bit more of an affinity for telling stories on Wall Street than others, but nevertheless, they love a good story, and you don't have to be public to have a good story to tell. Don't go to do clinical work with a prototype. I'm amazed at how many people do that. Because you go to the clinic, it doesn't really work the way it's supposed to work, and you're making excuses all the time, and you can't sell the product or technology to anybody because you haven't finished the product. You haven't finished the project. So think about the concept of, I want to actually produce and go to do clinical work with a real commercial product that's fully vetted, fully verified, and that you've done all the work to be able to get there. Yeah, you want to do some experimentation, fine, do that with animals or do that in some other kind of model, a benchtop, et cetera, et cetera. You want to do a little clinical work. Well, it takes a lot of effort to do clinical work. You just can't go and treat humans. Well, it's impossible to do it in the United States for the most part, right, initially. So if you want to go to whether it's Europe or South America, whatever, you can't skip steps. You still have to have all the elements in place. You have to have safety data, and you have to have your quality system in place and all those kinds of things. So, anyway, that's my philosophy. Now, the other thing you need to be aware of is that everything takes longer than you expect. I don't care how good you are and the people are great and so on. So it just takes longer than you think on paper. And it always costs more than you expect. So you have to think about that when you're out there raising capital, all that. I'm back to the fast follower idea. If you show me an idea and it doesn't have 7 competitors already in the field, and there's only 1 or 2 competitors, and you think, wow, we could do a much better job, then that's a good project because there's already a market. People can can relate to it. There's something tangible you can put your arms around, as opposed to these fantasy ideas and fantasy markets. And then the last, and probably the single most controversial thing that it seems that people say to me, that I say all the time, which is the best time to sell your company is before you ship the first commercial product. Okay? So you're sitting in your MBA classes or business classes or whatever, and there's this traditional thinking that says you do step A, step B, step C, you develop your product, you go out and you sell it, and if you sell it, they will come, right? Well, man, that's hard. That is really, really hard. So if you've got something that's really cool, why not package it up and offer it for sale? And besides, if the strategics don't want to buy it, well, then you're going to learn a lot about what went wrong? What went wrong? What do you need to do? But remember, a large company is not going to buy a small company's technology, even if you have some revenue. I mean, what does it matter? So you killed yourself to generate $2 million in revenue, $5 million in revenue, $10 million in revenue, $15 million in revenue. I mean, unless you went from 0 to 15 million in 1 year and it looks like it's going to be 50 the next year, that it doesn't matter to these large companies, right? They want good products, good technology that fits into their line of selling. So in any event, that's what I believe, and I think it's it's the reason why, if your intention is to monetize the invention and to monetize the investment that people make in your company and your project and yourselves, then you'll be successful in raising the capital that you need. But you've got to be able to show people that there is a way to get a return on that investment. And it is not in a spreadsheet that the fantasy projections that show you the hockey stick stuff. It's fantasy. It's made up. Everybody knows it's made up, right? But every PowerPoint and every business plan is supposed to have these. Well, I say put a market slide in there. Show how big the market is. Show what the competitors are doing. Tell them about your plan to go out there and make some money, not by necessarily fabricating and selling your product. The amount of money it takes to champion a real sales effort with any product in the medical arena is huge. Rule of thumb, it's $50 million if you want to do it right. So that's a sobering concept. But if you want to do it kind of, not so right, you can get by with string and bubble gum, right? So anyway, I'll stop talking, and I appreciate your willingness to listen to my ramblings, and I'm open for any comments or questions you might have. Yes, thank you. Thank you, Fritz.
Sales, but then you're stuck with the milestone payments, and 50% of your earnout was due to milestones that you didn't have much control over.
Right.
And the other company had screwed it up and pulled their product, ablation, had taken it off the market. So don't you think, I mean, you got to weigh that somehow. Instead of 200 million, you could have had 400 if Medtronic hadn't pulled theirs off the market because of bad results. So I don't know. I mean, every time someone has milestone payments like that they don't have any control over, they never seem to get the full earnout. Yeah.
Well, I mean, there's a lot of statistics, and this is not a secret. There are companies, third-party organizations, I'm trying to remember the name off the top of my head, that actually have done this analysis and show statistically what percentage of earnouts are made and how much and all that stuff. So it's true. If you can do a deal that doesn't include milestone payments and earnouts, you're better off. I mean, cash is cash. We all understand what that's worth. None of my investors are crying about the deal, okay? So you turn 27 million into 200. Plus, people are pretty damn happy with you. Okay,
so your original investors were completely washed out? Or
what do you mean washed out? I mean, they got these big fat wheelbarrows of cash.
You said the 27 million was what you raised. You raised the 27, but you had already you said there'd been a lot of money invested in the company before you came to turn it around.
Not a lot, but, but this is common. I mean, and I'll answer it generically. The last money in rules the day. That's just the way it works. That's just the way it works. So, investors are big boys and girls, and the only way an investor maintains their pro rata ownership is by writing checks. And if you have investors that can't write checks, then they're going to get diluted, and that's life in the big city. So,
One more. How do
Yeah.
I get a discount out of Stewart Carton?
yeah, Carton Design. That's a good design firm in Marina Del Rey. Highly recommended. I don't own any shares in the company. Yes. Other comments, questions? Sure.
Any tips on hiring great people other than paying them a lot? Can you just repeat that?
Yeah, I heard it. Any tips on hiring great people? Yeah, I mean, boy, I don't know. That's a hard question, right? It's a hard question. I think, so from my experience, what I would say is this, right? I assume you have an early stage project. Okay. Don't hire somebody from a large company. Okay? Particularly don't hire them directly from a large company because they don't typically have the breadth of experience that's necessary in an early stage project. Okay? You want to hire people with scars on their back and experience in doing more than one thing. And I think in large companies, people get siloed. You know, they have a certain discipline that they're responsible for. They don't get to see all the different things. And this is not an age thing, right? There could be a young person who may have been, at the bottom of the pyramid of a project that they saw a lot of things happening. So that would be kind of the opposite. And then, you just have to be careful. You don't want to hire pretenders, right? People who pretend that they know what they're doing because they can yap, 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 but they can't actually do the work, right? So it's all about, you got to figure out if people can do the work. My colleague, who I've worked with for a number of decades, who runs engineering for my projects, he gives people an IQ test. I mean, it's nasty. I couldn't pass it. But the point is, I'm not engineering either. So, this is what people do. So, and then the other things, I think it's all about fit, right? It's all about chemistry. So you want to hire people who, that you like them right away because they're authentic and you can tell they're motivated and all those kinds of things. So it's hard to answer really that question, but I would just caution against, I used to, look, if you give me a Medtronic business card or Boston Scientific business card or whatever, man, I can do anything, right? Because I got these huge company behind you, right? But the people who've actually done real work and broke rocks in the desert, man, those are the folks that you want on your team, right? Sir.
Where does the best time to sell your company for the first commercial product fit in for a medical device? Where does that, best time to sell your company, where does that fit in with the whole CE marking FDA process? Because you might get a CE mark way before you clear the FDA and could have the opportunity to sell in Europe. So where does that fit in?
Sure. So in the order of things, it's very difficult, if you're talking about clinical work in the United States, it's very difficult to get an IDE approved unless you've treated another nationality of humans. Okay? I think it's not impossible, but I think any of us who've been around would pretty much agree with that you're going to have a better opportunity to get an ID approved in the US if you've done work somewhere else. Okay, so now I'm backing back up, right? So, getting a CE mark is a big milestone, and it shows that not only do you have a good quality system in place, but you've done the type of validation and verification work that shows that the product is safe. Okay, so it's a really valuable thing to do. Maybe not so much efficacious, but certainly the safety part is where you're going to get the boxes checked for CE mark. Just because you have a CE mark doesn't mean that you need to go rush out and sell your product. Okay? My personal opinion is that you should hesitate to do that, and that because it's expensive and because it's complicated, right? If you're an American-based company and now you're going to try to sell in Europe and you've got different reimbursement system and on and on and on and on, right? And trying to manage people across the pond and, it's expensive. And to do it well, and you're going to say, well, I can use distributors. Well, okay, great, but now you're in the process of becoming an expert on distributors in a given market and all these things. And then the other mistake is that people, they respond to inquiries from different distributors. They get all excited, and we can ship some stuff, and then you change your focus of your company, and now you're trying to support people, and you know what I mean? It gets, and what do you get in the end of the day? All this churn, but what does it add up to? And distributors could screw up your reputation. They could do something with the product that you don't want to have done. And the mistake people make is they go wide instead of going deep, right? So I would say if you want to sell something and you have a commercial product and it is CE mark, pick a market, one market. Pick one city or one hospital in one market. Now that's pretty dramatic, I say it for effect, but one country. Show that you can sell product and the dogs want to eat the dog food in that market, and then you can extrapolate, right, the information. But the last thing you should do is go wide and just make create a big confusion racket for yourself. So does that answer your question directly? Okay. So, I think that's important. No buyer, no large company buyer expects a small company with a cool new invention to be great at selling and manufacturing. Right, you were the inventor. You came up with this cool idea and you made it work and you proved that it was safe. But you know what I mean? It's a different skill set. And today the market is so much more difficult for startups. And there's always the unicorns. So be careful about that, right? I can tell you a story about one particular company that has a neuromodulation device for pain, and it just got started, and people love the product, and they were right time at the right place, and all that, and their sales went from 20 million, and they're going to do 200 million this year. But that's I can only name in 35 years. There's less than 5 companies that I could name that have ever done anything like that, and they have went public. They have $1 billion market cap. So, but you got to be careful because that's a lot of great things conspiring. And by the way, this company that now everybody thinks this is a fantastic news story raised over $100 million, and it took 10 years for them to get their product to the market. So, other? Go on. No? That'll do it? Yes, yes. I'll repeat it if you say it.
Now it's working, okay. Ray, actually, before I ask my question, I just wanted to point out that Sharon Riddle, who's sitting right here, helped one of my earlier adventures do an overseas study. So, Sharon, maybe I'd recommend speaking with her.
And since we're doing a commercial for Sharon, Sharon was also involved in Vesix Vascular in a senior level in our company and knows so much stuff you wouldn't believe it. You should talk to her. Okay?
Yeah, I agree.
And she works, at a modest fee.
10% cut for each of us on this. So, the mission of what we're trying to do here with this grant program, I'll try to be coherent in my question. It's this whole theme about lean. $200,000 here, $100,000 there. Almost, it usually involves a prototype in the clinic. Certainly the NIH SBIR programs push this philosophy. There are seed funds, et cetera, et cetera. I would love your opinion in terms of A, is that necessarily bad? And B, what would you recommend we do?
Yeah, it depends. So a lot of this also depends on what stage in your career are you at, right? And you got to get started. Everybody's got to get started somewhere with something, right? So it depends. For me, I don't have the patience or time for that, right? I just don't. It just takes a long time. It's years and years of little amounts of money and moving the ball, kind of slowly down the field. So it's okay. And if you've never done a project before and you're trying to get, some experience and prove your bona fides, then it's a legitimate way to go. But the reality is that people, good people with good ideas get funded, okay? And maybe what you need is to seek out the right kinds of advisors and directors and people that are somewhat connected to larger sources of capital that could, how should we say, assist you in getting to that larger bolus of capital so that you can do stuff. I personally don't know how you do projects without capital and without the people in the company to do the work that's necessary to move the ball forward. I personally don't know how to do that. So it's like a direct relationship in my mind between, you know, really smart people who work and a team of them to get stuff done. Otherwise, it just takes forever, you know. So,
yeah, I can write a book on that.
Yeah, well, and you know, it just takes time, right? It just takes a lot of time. So, and that's the challenge, right? If you're an academic or, you know, somebody who's got an invention or an idea and you haven't done this before and you don't have that experience, then it's challenging. I'm the first person to admit it. But you need to think about what is your objective and maybe go back and think about what is your plan? What are you telling people that you're up to, right? In other words, what's the end goal? Think about that. I mean, I don't want to harp on it, but if you got a project and you have not sat down and thought about who's going to buy this, not what the customer is and the end user or the physician specialty or whatever. I'm talking about which company on the planet is going to want to own it. If you can't answer that question, you have not done the amount of work that you need to do. You really need to answer that question because the enlightened investor is going to ask you that question. And you may have a number of people that you come in contact with that for whatever reason don't answer that question at first. But when you get, you know, where there's 7 digits involved in capital raising, I can assure you that question's coming up. So,
maybe one. Does anybody have a question before I ask the terminal question? No? Okay, this is going to be cheesy.
All right.
In one word, how did it feel when you finalized your exit to Boston Scientific?
So there's only one. This is a really interesting question. And I'm sorry to give you more words.
You got plenty of time.
Okay. The only feeling that I had, which actually was shared by all the members of my senior team, was relief. Okay, relief. Okay? The joy and the excitement, it all came much, much, much earlier in the process. Like when we accomplished something and the product worked, or we treated the first patient, like, wow, you know what I mean? Those milestones along the way, man, they were really exciting and really motivating and so forth. And when we, you know, went and made the first presentations got those meetings together and were pitching the story and the big companies were leaning over the table and they were interested in potentially acquiring us, man, that was exciting, okay? And then once you get in the process, oh my God, it's so nerve-wracking, you know? That when it's over, it's just like, oh, thank God it's over, you know? And then when the money hits your bank account, then it's like, wow, that's really great, okay?
Is that like a Shazam?
Yeah, that's the moment, you know, so. But between the start and the finish, it's really nerve-wracking, no doubt, so.
Sorry. And by the way, you have to go back to work, but I have to say your threads were very nice.
Oh, thank you.
Yeah,
welcome.
so you didn't, let's thank Ray.
All right, thank you.
And Ray, you're welcome to hang out. I'd also like to thank Bill and Mark again for their excellent lectures for us. And I encourage you to mingle. And for those of you who are panelists, I'll see you at 2 o'clock in the same room. Thank you, everybody.
There you go. Thank you. Nice to meet you. Okay. Hey, how are you? What's going on, man?
Not much.
Yeah? You making progress?
Yeah, a little bit. I was going to say we should catch up at some point.
Okay.
Probably closing something.